My name is Daniel Flans. I'm going to be presenting bike crash litigation here in New York. So I can get a feeling from my audience, how many of you ride? A couple. Those that you don't ride, what's the biggest reason you don't ride? Safety? All right, convenience, a lot of reasons in New York. Look, New York is still, last year, Bicycle Magazine called New York the best cycling city in the country, but they still have a long way to go. All right, so let's talk a little bit what I do. I've been a personal injury lawyer for 20 years. For the first 15 years of my career, I basically was handling general personal injury cases. In the last 5 years, my practice has really become about 50% representing cyclists. It's kind of fun about what I get to do. A lot of you might represent bankruptcy or be involved in bankruptcy work. How many of you could say, hey, I've also filed for bankruptcy, right? I ride a bike, I relate to my clients. When they're involved in a crash, I understand what's going on. So I'm going to test you guys a little bit about your skills and knowledge of bike law in New York. And you get the opportunity to win a New York Bicycle Lawyer bike light. Anybody else give away gifts so far today? All right, cool. First question, in New York, are helmets mandatory for children? Yes. First, who's the first yes? Somewhere up there. No? All right. Somebody come claim that first bike light. Yes. Second question, to what age is a bike helmet mandatory? On children. Sorry, I'll be clear. 13 was the closest. 14. All right, you guys can come collect your bike lights at the end. How's that? What age must a child be before he or she can ride on a bike in New York? Wow, you guys don't know anything about bike law, do you? This is going to be a good lecture. Anyway, so what age before they can even get onto a bike in New York? 4. Nope, child has to be at least 1 year of age before they can get on a bike. All right? And can a child ride on a handlebars in New York? Okay, child needs to be affixed to a properly affixed certified bike seat, typically to the frame. Can ride on the handlebars. You see some of them on the handlebars, but it needs to be an affixed bike lane. All right. Second test, we're going to go back to kids again. And I have to make a little caveat with this one. I made a mistake on the PowerPoint. Is it legal for a child to ride on a sidewalk in New York City? Okay. Somebody else come collect your bike light. I keep hearing all right. To what age can a child ride on a sidewalk in New York City? Nope, to 14. All right. Is it a violation of New York State traffic law to ride on a sidewalk in New York State? No. New York State does not have a statute that prohibits riding on sidewalks. Individual cities do. New York City has its own administrative code, which makes it a violation. Long Beach makes it a violation, but New York State generally does not. All right? Now, here's a fun one. Is it legal to ride a bike and talk on the phone? Is it illegal to ride a bike? It is not illegal to ride a bike and talk on the phone. The only requirement you have while riding a bike with regard to a phone is you have to keep at least one hand on the handlebars at all time. All right? Is a seat required on a bike in New York? Yes. All right. Now, does everybody know what a 3 foot, before I ask the question, does everybody know what a 3-foot law is in New York? Or sorry, what a 3-foot law is? All right. So a 3-foot law is a law that prohibits drivers from passing a cyclist within 3 feet. All right? Does New York State have one of these laws? No. Somebody up there wins that question. It doesn't. It's one of the things that we're working on. There are some statutes that are similar and provide protection, and I'm going to talk about those a little bit later. But right now, New York State does not have a 3-foot law. About 26 other states in the country do. Legal to ride a bike intoxicated in New York. I'm not pushing it. I'm not condoning it. It's just a question. No. It is not illegal to ride a bike, and there's no requirement that you have to ride sober. There are other laws that could affect you by riding a bike, like public intoxication, but the riding of a bike itself is not illegal. All right, come collect your bike lights. I got like 8 of them. All right. So cycling crashes bring a lot of different things into effect for a lawyer. You're going to be dealing with issues for your client from no-fault claims, property damage claims, Bike crashes can involve other things other than cars. It can involve crashes such as road defects, product liability claims. All could come into play in a bike crash case. So it gives you a whole wide variety of law that you're dealing with. Most common insurance issues that you're going to be dealing with for your clients are going to be what's called PIP in other states. In New York, it's called no fault. And also what's real important is supplemental uninsured motorist protection. So what's no fault? And this is going to be your client's most immediate concern. No fault is a provision in the auto policy of the car that struck your client. Every vehicle in New York State has mandatory $50,000 in no fault benefits to cover your client's medical costs, ambulance transportation, emergency treatment, follow-up care, lost wages, incidental expenses following the crash, such as inability to clean their house, $25 a day benefit for that, lost wages. I could spend an entire lecture just on no fault, but I'm going to hit the high points for you just so you have some idea about it. All right. So the purpose is to allow the system to allow your client to be receive these benefits. The first thing you need to do is identify the insurance company for the car that struck your client. You can go about that doing different ways. Easiest way, it's going to be on the police report. Once the police report is obtained, there's going to be a 3-digit code on that police report. They'll identify the insurance company. You could also run the plate through DMV. Is an easy way to do that as well. Once you identify the insurance company, you need to submit a no-fault benefit application within 30 days of the crash. There are some exceptions to that 30-day rule if your client is hospitalized or disabled, but primarily you want to get that in within 30 days. This is going to be your main consideration. The bulk of my clients are relatively young, have just moved to New York, are working jobs that usually in the arts, in web design, and their health benefits are sketchy. And their biggest concern about getting into an ambulance after a crash is, this is going to bankrupt me. So you want to make sure they understand that no fault is going to protect them and their bills are going to be taken care of. Uninsured or underinsured motorist protection. First of all, those of you who raised your hand when I asked you if you ride a bike, this is a very important issue for you, and anybody that rides a bike in New York State should have an understanding of what this is. If you own a car, your own auto policy, even though your car was in the garage at the time the crash occurred, comes into play here. So there's two provisions. There's uninsured motorist coverage and underinsured motorist coverage. Uninsured motorist coverage is a circumstance where the vehicle that struck you or your client does not have insurance. You cannot have insurance because the policy lapsed, the person just didn't buy insurance, or it's a hit and run. All right? So a hit and run has some other requirements built in there. So if your client's struck by a car who doesn't stop at the scene and flees and is never identified, you could turn back to your own insurance company and make a claim for uninsured motorist coverage. The requirement for that is that the crash be reported to the police within 24 hours of the happening of the crash. So if I'm lecturing to a bike club and you guys are not a bike club, the one thing I'm always lecturing to bike club members is you're calling the police every time a crash occurs. Whether or not you think you're hurt or not, you want to call the police to the scene to make a report. And here's a perfect example. You get hit by somebody, you think you're okay, you let them leave the scene, you don't call the police, it turns out you're not okay. A lot of times people realize injuries do come up within an hour, 2 hours, 3 hours after the adrenaline wears off. They didn't call the police, they never identified the vehicle, they call their own insurance company to make the case, and the claim is denied because it wasn't reported within 24 hours. So we're calling the police after a crash. Underinsured motorist protection is a little bit more complicated. This involves a circumstance when you're hit by somebody who has the minimal amount insurance in New York State or does not have enough coverage to cover your client's claim. So give an example. You have a client who's struck, has a severe leg fracture, surgery, they're out of work for 6 months. It's a real horrible case, and the case is worth well in excess of $25,000, which is the minimum amount of coverage in New York State. By the way, you all know that? Right now in New York State, somebody can be driving around the road and can kill a father of 5 children, and the minimal amount of coverage they have to carry is $25,000. All right, and that family will be without a father, and the most they're going to get is going to be $25,000. So underinsurance is coverage you're going to purchase for yourself, or you're going to advise your clients to purchase for themselves to protect them. So with underinsurance is after you exhaust that $25,000 or that minimal amount of coverage, you could then turn back to your own insurance company and make a claim for the excess. So if I have $100,000 in underinsurance motorist coverage, the car strikes me, has 25, I collected 25, you now have $75,000 available to you. So when your client comes in, you're going to ask them the first question, do you own a car? And they're going to say, why? My car was in my garage, I was riding my bike 100 miles away from the crash occurred, my car had nothing to do with this. This is why you're identifying their car, their insurance, and putting their insurance company on notice as soon as you can. Property damage sounds a little bit silly to talk about, but I have clients that come in and have that broken leg with 3 surgeries. And you know what their biggest concern is? My $10,000 road bike. Who's going to pay for that? All right? So you need to be up on understanding about property damage cases. I shouldn't even say the $10,000 bike, because I also have the guys coming in with their vintage bikes that they spent the last 2 years rebuilding, and it's real important to them. In terms of evaluating the value of a bike, there is actually now a bicycle blue book. I don't give it any credit. It was created by the bike industry. I don't think everybody actually is going by it. The best way to evaluate a bike value is simply get on eBay, go look it up. The problem with a Cannondale from 2014, it's going to be a different model number, so I'm always going by what you can replace it with. You're also going to be looking for your client. A lot of people are doing add-ons, changing their pedals, changing things like that. You want to get all those receipts and include that in the property damage case. And also keep the bike. Tell them do not throw the bike out, don't repair it, keep it intact until it's evaluated, until the property damage case is resolved. And we're going to talk a little bit some other reasons why you're going to tell them to keep the bike. Bike tickets, real quick, another issue that your clients are going to be calling about if you are going to represent cyclists. Biggest thing you need to know about bike tickets, I won't get into how to defend them, there are no points on your license in New York State for a bike ticket. And that's everybody's usually most immediate concern, is this going to affect my license? And specifically in the New York City rules and regulations or New York State rules and regulations, it's an exception if you look at 131.3b, any violations involving pedestrians or bicycles are not on the New York State point system. All right, jury selection, a bike case. Any of you familiar with The Reptile, that chorus by Don Keegan? Any of you try cases? Anybody trial lawyers here? All right. If you're going to try cases, this is probably one of the best programs that I've run up against. It's a wonderful program, kind of teaching you a little bit how to understand jury psyche and how to get into their heads before you pick a jury. And the reptilian approach is what he talks about. And basically, it's the most inert portion of our inner minds that is about safety. So when you start to talk about bike crash cases to a jury, you want to make it about them, not about your client. Everybody's first instinct is survival. And their biggest concern, as much as you think they care about your client, they care about themselves. So you want to start to have the jury start to think about themselves, think about their family. Well, how do you do that? You ask them, do you ride a bike? Like I asked all of you, do you ride a bike? When they say they don't, ask them why not. And if they say safety, follow up on that. Continue to ask them questions about safety. Get them thinking about safety. Get them thinking about responsibility of drivers on the road. Ask them the last time they rode a bike. Did their friends and family ride bikes? Have them start thinking about their children. Have them thinking about their neighbors' children. Those are the people that we want in their head are riding the bike. That's what you want them to begin to think about your client. Talk about them and concerns on the road. Do they drive differently when they're around cyclists? Do they change their behavior? You want to make this all about safety and responsibility on the part of the driver. And ultimately, you want them thinking this. You want them thinking the little kid on the bike and not your client riding in the wrong direction, the Quicksilver messenger. Now, in a civil case, at the end of the case, you're going to be asked to instruct the jury on the law. The PJI is a pattern jury instruction. It's what all civil judges use in New York State with regard to charging a jury on the law. The PJI has not, at least the sections with regard to bicycles, has not really been updated very much. There's one section in the entire 2 volumes that have anything to do specifically with bicycles, and that's 2:76A. And this is the charge. It talks about the obligation of cyclists and drivers on the road and incorporates 2 sections of the VTL that we're going to talk about, and that's 1146 and 1234. All right, so 1146, this is built into the charge. This is kind of a catch-all vehicle and traffic law with regard to the duty of operators towards pedestrians and cyclists. And as you can read it, notwithstanding the provisions of any law and the contrary, every driver of a vehicle shall exercise due care to avoid colliding with any bicyclist, pedestrian, and domestic animal. My favorite part of that is they put us on the same level as a cow. All right? The only other section within that charge that incorporates a section of the VTL is 1122. So earlier when I was talking about a 3-foot law in New York, VTL 1122 is as close to become as a 3-foot law in New York State right now. And that's the operator of a vehicle overtaking from behind a bicycle proceeding in the same side of the road shall pass to the left of such bicycle at a safe distance until can be safely cleared. So we don't have a specific distance that you have to pass to the left, but as safely as possible. And then any other particular statutes that are going to come into play, you'll have to search the vehicle and traffic law, and they could be obligation of approaching at a red light, speed, all the statutes that involve operating a motor vehicle in New York State, and you'll plug them into these two sections of the charge. Also, New York City has their own rules and regulations. So in addition to the vehicle and traffic law, you could also plug in the applicable statutes in New York City or any other municipality in New York State. All right, preservation of evidence. So earlier, I was talking about telling your client to hold on to their bike. Well, not only are they holding on to their bike or any other parts of any other evidence, you're not just doing it for the property damage case, but you're doing it because ultimately the defendants are entitled to examine that evidence if the case goes to trial. So you're telling a client to keep everything stored until you can make it available to the defendants or defendants' attorneys to take a look at. This is the bike, the helmets, gloves, any other property damage that they're going to be claiming. Their computer, their road computer, their iPhones, things like that. You want to kind of make sure all that stuff is going to be saved and make it available to the defendants. You're then going to advise the defendants' attorneys, hey, the bike is here. You want to come look at it? Now's your time to come look at it. They don't look at it, then you at least have an argument to the judge later on when your client has moved from his third apartment and lost the bike. You say, hey, judge, we had them, made it available for them to look at it. They didn't want to come. Photograph it. God forbid things do get lost in a fire. They do get stolen. Broken bikes get stolen. People steal them for parts. You want to at least be able to have the photographs to show to a jury or to your adversary. And this is no joke. This case is First Department 2014. And as you can see, a cyclist is involved in a door-in crash in July of 2010. 2012, some 2 years later, for the defendants for the first time demand to examine the bike. The plaintiff's like, wait, I got rid of it. You never asked for it before. Lower court denied the motion for spoliation. And spoliation is basically having your case dismissed. If you get rid of evidence that's crucial to a case, a defendant could ask the judge and say, hey, judge, throw the case out. I needed this evidence. They purposely got rid of it. I can't defend this case now. Lower court denied that. Appellate division affirmed it. But they were very clear saying no evidence. Number one, you need to establish that the evidence is crucial in the case and that it was willfully destroyed. But it's kind of a warning to cyclists and plaintiffs' lawyers saying, if it is crucial and it is evidence, don't toss it out because we will consider about dismissing your case. So it's a reason why you're telling your clients to hold on to it. Electronic devices. Any of you obviously all familiar with GoPro? All right. A lot of my clients are now riding with GoPros. GoPros can be the best evidence I could ever ask for, or it could be the most damning evidence I could ever ask for. Reality is video tells the truth, right? I'm going to show you a couple of stills. This is really, unfortunately we couldn't get it working today, but the live video of it, but I was able to lift stills. So this is a case that I'm handling involving a crash that occurred in Brooklyn. And if you could see, under the arrow is a car approaching in the opposite direction, coming up on an intersection. My client is in the bike lane. This is his view of his GoPro in the bike lane as he's approaching the intersection. I'm going to back up for a second. There's a traffic light. It's hard to see in the still photographs, but the traffic light is green and the car is approaching. What I had really fun with this case is before I even played the video to the defendant at his deposition, I laid a long foundation. Sir, where were you coming from? Where were you going to? What did you do as you approached the intersection? He tells me I came to a stop, I put my directional on, I waited for traffic to clear, and your client rode into my stop car. Okay? That's what he tells me. Then I show him the video. It was the most fun I've ever had. It really was. The guy couldn't get it. He's like, that's my car, that's my plate, where did this video come from? And it shows complete opposite of him swinging this sudden left turn as he approached the intersection. So what you can see is as he approached the intersection, he makes the left turn, basically into the path of my client. There's no directional on, it's really obvious in the video. And there he is as they hit, and that's the view of my client on the ground. He survived the crash, had a pretty bad separated shoulder with surgery, but he did walk away from it. But again, the best evidence I could ask for. Again, this is another video involving a cyclist riding in Brooklyn in a bike lane. This involves a dooring, so he's in the bike lane. This truck is illegally parked. He's in violation of New York City Administrative Code, which prohibits stopping or standing in a bike lane, but he's doing it. The cyclist has no choice but to go around him. As he begins to go around him, you see the car door begin to open, and boom, he rides into the car door. Again, the best evidence I could ever ask for. Question then becomes, well, how do you use it? Because just because you have a video doesn't mean it's coming into evidence. Like anything else that's going to come into evidence in trial, you need to establish a chain of custody. So you need to make sure that when your client records that video, you have to keep a chain of it. How did it get from the GoPro to his computer? Did he then download it onto a disk? Did he then turn the disk over to you? And then did I then provide it to the court with an affirmation from my client? These are the procedures in how it was recorded, how it was downloaded, how it got to me, and that it fairly and accurately depicts the version of events as it occurred. All right? So you have to also lay a foundation in order to use the evidence when you get it. You're also going to start to look for other places where video. This was another one, unfortunately, I couldn't play for you, but this was a crash that occurred at an intersection in Brooklyn, and my client on his own went back to the scene afterwards and looked around to see if there were any video cameras, and he was able to find a video camera up on the side of the building, and the video camera caught the crash of the car driving through the red light and striking him. Thank God he survived the crash as well, actually didn't get too badly hurt at all. But the video was fantastic. So you need to go out and also send an investigator out, go out, take a look around for videos, whether or not they're storefront. Everybody has video cameras now. Every store, every residential building has video cameras. So go out and see if you can find it and if it can help your case. And don't stop there, because not only do the cars have video cameras, the bikes have video cameras, but so do the cars and buses. I was at a hearing at American Transit Insurance Company, which is the largest insurance company for cabs in the city of New York, and I'm sitting there at the hearing and I see this sign, and it says, "For your protection and safety of drivers, American Transit cabs are now equipped with interior and exterior surveillance cameras." So if you have a client that's involved in a crash with a cab, boom, you write out that letter, certified mail, to the cab driver and to American Transit Insurance and say, "Hey, preserve that video. We want that video. I don't want to hear you deleted it, you wrote over it, you're on notice, I want it." If they destroy it, the spoliation we were talking about earlier, about getting rid of a bike, well, now you say to the judge, they just got rid of my evidence, I want their answer stricken, and I want to go to inquest on damages. All right, let them come forward and say, this is how we got rid of it. New York City Transit Authority buses, hard to see in the photograph. I don't know if you can make it out or not, but there are cameras on the front of New York City Transit Authority buses as well. They're in the process of installing them on every single bus. You're going to write a letter to New York City Transit Authority or MAPSTOA or whatever bus company is operating that bus and say, preserve that video, download it, and I want it. Sending that letter certified mail. How about, you familiar with Strava? No? Okay. Strava is kind of like a Garmin. So you have Garmin and Strava, two most the most utilized ones right now, and these are devices that cyclists are using really to track their own performance. So usually using it, how far did I ride, what elevation did I ride, what distance did I ride, my cadence, my speed. But they also could be really useful in establishing speed and distance and routes. And to give you an example, this is a crash that occurred out on in Nassau County at the intersection of Glen Cove Road in Old Westbury. My client was riding on Glen Cove Road, and you could see his path in red, when a vehicle coming from the left on Old Westbury Road, coming from his left to his right, struck him. All right? He made a right on red, which was legal to do at that intersection. The defendant's going to claim, or does claim in the police report, that he made a sudden right turn in front of him. Well, I'm looking at this Strava, which recorded his route, and I know he's about 200 to 300 feet down Old Westbury Road before the crash occurred. So we now have some evidence with regard to his route and his path of travel. But again, you're telling your clients, going back to storing the data, keeping it safe, and keeping a chain of custody to get this data as well. Some of the other things that the Garmins or Stravas do is it shows you, you can see here, duration of time, speed, routes traveled, all critical information. It even does a nice Google map overlay, which is great to use as well. You know, when you're trying a case, just how you guys like to look at this demonstrative stuff, much more interesting than listening to me speak, a jury likes to see demonstrative evidence. If you can give them photographs, keep them awake, let them see things to show how a crash occurs, your story is going to be much better when you're selling it to them. So this gives you great stuff to put in front of a jury. I could sit here and talk all day about car versus bike crashes, but I want to talk about some other cases that may hit your desk that are not as typical. This is a case in the West Village, and this was an incident where a cyclist was traveling, I think it was I forget if Gay Street or about Gay Street, and he approached a cab that was illegally parked in a bike lane. All right, so we have one violation. Cab is violating section 4-08E of the New York City Administrative Code with regard to no stopping, standing, or parking in a bike lane. So the client is now forced to go outside the bike lane, and as he does that, I don't have a picture of it unfortunately, but the cab driver decides to exit his vehicle as he goes outside around the bike lane and doors him. And this is the aftermath. So now we have a violation of Vehicle and Traffic Law 1214, which we're going to talk about in a moment, which prohibits the opening of a car door into the path of traffic. A bystander was there, and he took the photographs, was a witness to the crash, and provided these photographs to us. And what was a first for me, and I had done this, this is number 6, I think. I've moved for summary judgment, which is asking the court to find as a matter of law that when somebody opens the car door into the path of a moving cyclist, the violation of Vehicle and Traffic Law 1214 is negligence as a matter of law, and if there's no issue of comparative negligence, meaning there's no issue whether or not my client contributed or caused to the crash, either by speeding or not being in the proper roadway position or not having a bike lane, or any argument a defendant can make that he somehow contributed to the happening of the crash, he should be entitled to summary judgment on liability because the opening of the car door was the sole proximate cause of the crash. I made the motion in Queens, New York County more than one time, Brooklyn a bunch of times. This case finally got me summary judgment. The judge looked at the photographs and it finally was able to survive summary judgment, and as of now has not been appealed. I also got a little benefit also because the driver was never produced for his deposition, so we only had one version of events, which was a big benefit as well. But the first time I got that granted, and the first time that I'm aware of that happening in New York. All right, so doorings, I was talking a little bit about that. So doorings are the opening of a car door into a path of a moving cyclist. They probably make up about 30% of my crash cases in New York City. It's very, very common. It is either a driver getting out of a car, passenger getting out of a car, taxi passenger getting out of a car. All can be situations that cause doorings. And like I said, it could be the door opening into a cyclist, which literally as he rides by gets the door open into him or her. A door opening into the front of a cyclist, which is like riding into a brick wall at 15 or 20 miles an hour. It could also cause other events. So circumstances where the door opens and there's no contact, but it causes cyclists to lose control of his bike and crash, God forbid, get pushed into oncoming traffic or into a car coming up behind him. It causes a lot of scenarios that are incredibly dangerous for a cyclist. So what's the statute in New York? New York State Vehicle and Traffic Law. No person shall open the door of a motor vehicle on a side available to moving traffic until it is reasonably safe to do so and can be done without interfering with the movement of any traffic, nor shall any person leave a door open on a side of a vehicle available to moving traffic for a period of time longer than necessary to load or unload passengers. All right, so we're going to come back to the second half of that statute when we talk about defenses in these type of cases. But remember, for the purposes of vehicle and traffic law, a cyclist is considered traffic. A cyclist is considered a vehicle. So this section applies to a cyclist as well as cars. And New York City 1214 is relevant in both New York State and New York City. So New York State has its own vehicle traffic law, and New York City has its own administrative code. And certain sections of the administrative code of the city of New York supersede those sections of the vehicle and traffic law of the state of New York. So example, speeding. The VTL 1180 and 1180A, which is the statutes that are applicable in the state, are superseded by 4-08, I forget the subsection, of the New York City Administrative Code. However, for doorings, the 1214 is applicable, and in addition to 1214, you also have New York City Administrative Code has its own dooring statute as well, and this is getting out of a vehicle. In New York City, no person shall get out of a vehicle from the side facing on the traveled part of the street in such a manner as to interfere with the right of an operator or an approaching vehicle or bicycle. So what I like about the New York City Administrative Code, it actually even incorporates bicycle into the statute as well. Now, what's the difference between a regulation and a statute? A violation of statute, like the vehicle and traffic law, is negligence as a matter of law. So when I ask a court to grant summary judgment on a violation of statute, if there's a violation of that statute and it's a proximate cause of the crash, it's negligence as a matter of law. A violation of a ordinance, rule or ordinance, like New York City Administrative Code, doesn't have the same full weight and effect. The statute says it's some evidence of negligence. So to be able to have both the vehicle and traffic law and the New York City Administrative Code is really a great opportunity in a dooring crash case. Also in New York City, if your dooring involves a New York City cab, you also have the ability to also rely upon Section 4-11, which requires taxis who are picking up or discharging passengers to be within 12 inches of the curb. So if they're out in the middle of the street in the second lane and your client is doored as he's passing in the right lane, you also can rely upon this statute as well. Now, what are common defenses you're going to see in a dooring crash case? Like I said, if I want to get summary judgment, I got to prove my client wasn't comparatively negligent. So what is the defendant going to do in circumstances like that? He or she starts, for example, the defendant is going to say, my door was open for a minute and your client just ran into my open door. Okay, so let's go back and look at VTL 1214. No person shall leave a door open on the side of a vehicle available for moving traffic for a period of time longer than necessary to load or unload passengers. So what was your door doing open for a minute? How long does it take you to get in and out of a car? Yep. Question?
Yeah, suppose the cat bear opened the door, can you have him come?
Yeah, that's a really, really good question. And by the way, if you guys have questions, I said at the beginning, I know this stuff. I'd rather have you guys ask me questions and ask me things that you want to know versus what I'm telling you, all right? So, two issues. Number one, in New York State, yes, the passenger you could have your own individual action against the exiting passenger. And I've had circumstances like that. And so what you hope for is if you identify the passenger because he or she stays at the scene, and let me repeat the question. So the question was, the question was whether or not a passenger who gets out of a vehicle can also be responsible, and can you name that person as an individual defendant in the case? So the answer is yes. You need to be able to identify that person, number one. And number two, does that person have assets, have insurance coverage to affect that? So I had a circumstance in the West Village where the woman was identified by the cab company because she paid by credit card. They provided us with that name. We named her. She lived up in Westchester. She had traveler's insurance. They hired her attorney. They answered on her behalf. And actually, we resolved the case majority with her insurance company and not the cab company. Unfortunately, in New York City, a lot of people don't stick around. You have a lot of tourists, and a lot of times they're never identified. So what do you do in that circumstance, right? And this brings me to a really good point. There's a case called Cole, which went to the Court of Appeals. And it deals with circumstance where a passenger got out of a car and they sued the cab company and the cab driver and the cab owner, and the cab insurance company tried to disclaim coverage and saying, we didn't do anything wrong. The passenger is the one that got out of the car. The passenger was the active tortfeasor, and we don't have to provide coverage to that individual. And the Court of Appeals in Cole said, no, it's use and operation of a motor vehicle. Your insurance is covered for use and operation of a motor vehicle, so you need to indemnify this event. Not that you don't have to answer and defend that individual driver, but you're still negligent with regard to the opening of the car door and still responsible to indemnify that case. Now, it brings us to a real interesting issue when you come to try that case. You have to convince a jury, I know legally under 388 of the Vehicle and Traffic Law, any driver or owner of a vehicle is responsible, vicariously liable for the acts of the driver. How do you explain that to a jury? And there's no specific charge. So you have to kind of argue to the jury or try to set up the case in a way saying to the driver, where did you stop? Did you say anything to the exiting passenger before he or she got out? Did you have that little sticker, which we do see on cabs now, saying exit curbside only? I think a lot of these cab cases are ultimately going to disappear with the cab of tomorrow, because the cab of tomorrow has sliding doors. So it's probably going to be a non-issue for these cab companies, but it brings us to a really good point. So you want to prep your client when you're defending, you're representing your client. The questions they're typically going to ask is, how much time elapsed from the time that car door opened until the crash occurred? So, typically, usually, and this is not even me prepping my client, typically the circumstances are somebody's passing basically that rear tire and the driver's door opens. We're talking about less of half of a car length before that occurs. When you're asking, you're always going to be preparing your client for that particular question. The other things you want to ask or be able to have them answer, was there anything that was going to let you know that somebody was in that car or that somebody was going to be exiting? Meaning, did that car just pull up to the curb and is there directional on? Is there something to make you think that somebody was going to be getting out of that car? Were there interior lights on? Was there foot on the brake? Also, you want to talk about their position on the roadway. Meaning, were they riding so close to the car that they were well within that door lane? And if they were, is there a reason they were in that door lane? Because there are cars to their left, and that was the only safe place to travel. So these are all the things that a defendant is going to hammer you on your client in order to try to answer that question that you just asked, as why didn't they stop? All right. I'm giving you guys all these are cases that are actively ongoing or I have had. This was in Brooklyn again, and this was a case involving a newly installed speed bump. All right, so look, part of Vision Zero is all these traffic calming devices that are going into effect, including speed bumps. This is actually in front of Pratt. So there was an area in front of Pratt that the school asked, can you slow down traffic here? They did a whole study about it, and they said, sure, we're going to install speed bumps here. Well, does anybody see a speed bump in that photograph? No, neither did my client. And there's a reason for that. It was installed and underneath some trees, and what's typically required after a speed bump is installed is that it's painted. This one was never painted and was left unpainted for about 3 weeks. And he's riding his bike home at night one night. It's in not a lot of bike lights in that area. And it's not a very dramatic speed bump, but it doesn't take a lot to throw somebody off balance on a bike. Things that are meant to slow down cars can be fatal to somebody or really seriously injured to somebody on a bike. So he hits this speed bump, he falls and crashes. About 3 weeks later, you can see they came out and put bump on the street, bump ahead. There's a chevron now on the speed bump itself, which should have been there at the time. There's signage now that says speed bump ahead. So these are all the things that you're going to be looking for when you're involving defects. And that was earlier coming back. These cases can take all different types of shapes and sizes. So if you're handling any cases involving a New York City or New York State road design case, especially in the city of New York, there's a lot of great resources for you to take a look at to see whether or not the condition that caused the crash, and it could be anything from a speed bump to ongoing construction, lots of different things. There's the New York City Master Plan, which is a design guideline for everybody in New York City with regard to the installation of any type of roadways, bike lanes, things like that. There's the New York City Traffic Calming Design Guidelines. So traffic calming devices are speed bumps. They're circles that you see. Now in Queens, you're starting to see the rotary circles. They are sharrows or narrowed traffic lanes now that you're starting to see, like as you get to an intersection, creating wider sidewalks and pedestrian paths are used to control and slow down traffic. All those things are going to be in the New York City Traffic Calming Design Guidelines. The New York City DOT Street Design Manual, again, a great resource for any type of road design case. The go-to, the standard with regard to any of these types of claims is what's called AASHTO. And New York City uses it in some part in their designs, and it's the American Association of State Highway Transportation Officials. So this is a monstrous resource to dig through, but it's every single protocol with regard to street design in the United States. And that's from placement of stop signs, stoplights, all the different things that would go into designing a street. So this is something that you want to be taking a look at when you start getting involved in street design cases. And like I said earlier, roadways have to now be considered for mixed use. Years ago, nobody ever thought about a bike being on the street. When they designed a roadway, when they installed the traffic bump, when they installed traffic lights, sidewalks, they never considered whether or not a bike is going to be using that road. I just got called from a cyclist that was injured on a storm grate. Nobody ever thought on roadways that bicyclists are going to be riding on a shoulder and whether or not storm grates are going to be safe and make sure that a tire doesn't get caught in it or doesn't have a lip or doesn't have an edge. But these are major, if anybody's familiar with 9W, it's a major cycling route for cyclists in New York City. It's a place to ride up to Bear Mountain. There are some horrible defects along 9W, and it is the most majorly ridden bike route from New York City to anybody that wants to get out and do some mileage. And there's some real design defects along there and some real dangerous conditions. So you need to be looking at whether or not, when they design the road, do they consider mixed use. There's a whole bunch of different issues that get involved in road defect cases about governmental immunity and design decisions that, again, can be a whole separate lecture. But you're going to start to look at these things. Now, here's an example of failure to consider mixed use. This is right over, and it still exists. This is the 34th Street heliport. And what I believe has different names, but it's the Green Belt or the East River Bike Path. All of this brings you basically from Lower Manhattan all the way up the east side, along the East River, to continue biking all the way uptown. And there's an area as you get past the 34th Street heliport where it diverts around the heliport because the helicopters obviously are taking off and they don't want the bicyclists in between the helicopters and the roadway. In there is a speed bump. And nobody ever thought about anybody using that speed bump other than cars. And I understand the purpose, what it's there for. It's there because immediately behind this building, there's a parking lot, and they wanted to slow cars coming down off the FDR. So people are parking in that parking lot and crossing this area road. But they didn't consider whether or not cyclists are going to be using it, and it was installed by the heliport. And I know it seems very obvious in this photograph with the flash, but when you're riding a bike, the one thing you have to remember is cyclists have a lot going on around them, especially in New York City. You have to be looking with your head on a pivot. You have other cyclists, you have cars, you have potholes, you have a lot of other things going around you. And in this circumstance, you also had helicopters. All right? So this guy is in a circumstance under the FDR, it's shadowy, it's dark, and he didn't have an ability to see the speed bump, and he fell and fractured his wrist. All right? Is there some issues of comparative negligence for him? Maybe. Maybe he should have been looking a little bit careful, but he didn't install that speed bump. All right? And they had the first obligation to put it in and put up a sign and say speed bump ahead, especially knowing it's a major cycling route. I just practiced my summation there for you guys, right? All right. And here's a proper example of what you expect to see. And this is really just this is the apartment buildings that are along the East River, probably, half a mile south of that. There's a complex there where the bike route actually runs past, but this time it goes a little bit to the left. But you expect to see caution, speed bump ahead, bright yellow paintings, the yellow bars next to it, the yellow statutes next to it, or whatever you call those little things, advising cyclists that there's a speed bump there. All right. So when you get involved in these type of cases, there's certain documents you're going to be looking for. Really great resource is, number one, FOIL, New York City Freedom of Information Law Request. So you're sending a certified letter to the state or to the New York City DOT, and you're foiling these records. Right? Technically, they're supposed to respond. I believe it's within 60 days. I'm getting letters now saying we'll get to it in 150 days. You have options at that point. At 150 days, if that's what they respond to you, it's technically an administrative denial, and you could then bring an Article 78 proceeding to compel them to produce the documents, or you can kind of wait it out. It all depends upon your time period. I've always found them to respond. The question is whether or not they do it timely. One issue you have when you're suing a municipality, such as the City of New York, is you need to file a notice of claim within 90 days. So you're trying to investigate a case pretty quickly, and if they're telling you that they're not going to give you the records for 150, and you have to file within 90, your hands are kind of tied, and you end up filing the notice of claim first just to protect your client. But 311 complaints, great resource. Cyclists are incredible advocates, and if there's a road defect or a really bad road condition, they call 311 and report it. So you want to check and see whether or not that has been reported before. You're going to request corrective action reports. CARs or CARs are the response to the 311 call. What did DOT do when they got that call? You're going to foil contracts when you're dealing with circumstances involving construction. A lot of my cases are not the active tortfeasor is not the City of New York, but a private contractor such as Con Ed or anybody doing construction in New York City streets that didn't keep the road safe in a bike lane or for cyclists. You want to see is there a contract in that area that they issued. Prior notices of claim. Like I said, when you bring a claim against the City of New York, you need to file a notice of claim within 90 days of the crash. You want to see whether or not anybody else ever filed a claim before yours. You want to foil those. Fitch reports are, again, repair reports. Big Apple maps are maps that were created that's actually kind of out of business, but years ago it was by a company that would go around and map all defects within streets in the City of New York and send them to the DOT. You want to see if those exist. Also, don't forget to foil emails. And going back real quickly to this case that I showed you. All right, this one. The reason I know that there was about a 3.5-week lag between the installation of that speed bump and the placement of the signage and paint was because I found an email on my FOIL request from somebody at DOT to the people at the paint department saying, hey, did you ever go out and paint that speed bump we just installed? And he's like, no. He's like, you got to tell us when you install this so we know to go out and paint them. All right? If I didn't request emails in addition to all my FOIL requests, I never would have saw that email between the two of them. So you want to make sure you're considering you're foiling emails as well. And look, it's the reality is how most of us communicate now, at least within city agencies. All right. So what's supposed to be present? Nobody can do any construction in a New York City street without first obtaining a permit. So every single permit that is applied in New York City, and I'm talking about Verizon, Con Ed, or anybody building a building, is going to have stipulations. And then when it comes to affecting bike routes and bike lanes, there are going to be specific stipulations within that permit with regard to when a bike lane can be closed, how it can be closed, and what needs to be done to safeguard it. So for example, it has to be signs. Usually it says 300 feet before you approach the closed bike lane, there needs to be signs. Another 100 feet before the bike lane, there needs to be signs. Are there flagmen that are required to be present? And I'm going to show you a case involving not having flagmen present. But this is somebody to stop traffic or advise cyclists or pedestrians that there's construction ahead. You want to see if those things are present. Road restoration, another huge issue. We all see areas with New York City streets that have been constructed, repaired, excavated, and they're now collapsing. All right? And that's happening because they weren't properly excavated and they weren't properly restored. So the proper way to restore a road sometimes takes a little bit longer than the contractor wants to sit around and do on a job. And it requires compacting and making sure the road doesn't settle after it's paved. So you want to take a look at not only the permits and applications for the actual construction itself, but what was required to be done when it was finished, and in what situation, and how does the road have to be restored and put back into the same condition it was before. And also, if they are modifying a bike lane, it also has to maintain a certain width. You know, nobody rides a bike perfectly straight. Right? Nobody drives a car perfectly straight. There's always going to be some deviation when you're riding just for the sake of balance. So typically, if a bike lane is supposed to be by minimal standards 4 feet. So if you have an area, and I do have give another example of a case, it's construction on the Upper East Side. They had to move the bike lane on First Avenue into the street, and they created barricades to do that, moving the bike lane and the sidewalk over. Every day they would get deliveries for this construction site. And every day they would move the barricades that created the bike lane to get construction material in and then close up the bike lane. And one day my client is riding through that bike lane, and whoever set up those barricades that particular day put them too close together, so as he travels down through the bike lane, his handlebar hits the edge of the wood barrier. Because it's well short of now 3 feet, he falls and fractures his shoulder. If you look at the stipulations on that job site, it's required to be standard of 4 feet. We went out there, took measurements, and it wasn't. So you want to be looking at things like that with regard to those standards. And there's people that would argue that 4 feet still is not enough. A bike handlebar is approximately 24 inches. That's giving you a foot variation on each side. It's not a lot on a bike, especially if you're considering what's in a bike lane. There could be potholes, there could be a lot of other things that can make you depart from that standard of 1 foot left or right. So how do you investigate a street defect in a roadway condition? Number one, photograph it. If it's an ongoing construction project, these things change daily. So the sooner you can get out there and take photographs, you want to get it and get it locked down because they are transient conditions. Foil, what I just talked about earlier. How do you identify the proper parties? You get out to a job site, there's a bunch of trucks, there's a bunch of men working, some have uniforms on, some don't. Simply look at the job site or have your investigator look at the job site. There's going to be a permit hanging somewhere on that job site wall somewhere. It's going to tell you who applied for the permit. Look at license plates. There's a bunch of construction vehicles around. Jot down the license plate. Have your investigator do that. Run the plate. You know who owns the vehicle. You know who's out there working. Look at the barricades. A lot of the barricades have the construction companies marked on it right away. Street plates. You all know what street plates. You see those all over the place. They typically have markings on them as well. Con Ed, they're usually coded. So I think, like for instance, Con Ed's, I think it's CGO, like it's for gas. There's certain codes that Con Ed uses for their plates for different divisions in Con Ed, but the markings are going to be on the plates. Now, the only problem with using barricades or plates is a lot of these construction companies steal each other's equipment. And they'll be the first to admit it, saying, yeah, that's not my barricade. We took it off a job site on 95th Street. It really wasn't ours. We weren't there. And the same thing with construction plates. They all steal each other's construction plates. So you want to also verify when you use that system to do it. And the other thing is you want to hire an expert. Some circumstances require an opinion whether or not the standards being used by that construction company at the time of the crash departed from the standard of care or industry standards. So do you want to go out and get an expert to have them look at the site? All right, so 12-inch rule. This is a rule in New York City that requires anybody who installs any type of street hardware in a New York City street to maintain that hardware flush and safe within a 12-inch perimeter of the street hardware. All right, so that's going to be a manhole cover, a Con Ed vault, New York City Fire Department. Every time you see a hydrant, there's going to be a valve cover about a foot off that curb so the fire department could shut off the water when they're working on that fire hydrant. Everything that you could imagine is street hardware. Verizon has street hardware in New York City streets. Everybody has street hardware buried in New York City streets. Right? The obligation stays with that company from the moment that they put that hardware into the street to maintain that hardware up until the time your client has an unfortunate crash if it's not maintained. So this is the rule that covers the obligation with regard to private contractors. It also is the obligation with regard to the New York City. However, it gets a little bit more complicated with New York City because you need to establish that that hardware was there for the specific benefit of New York City. It wasn't something that Con Ed and New York City are sharing or multiple people are sharing. So by example, using that fire hydrant, nobody but the New York City Fire Department uses a New York City Fire Department hydrant. So if there's a vault that's in front of that to control that hydrant, that's for the specific benefit of the city of New York. So it gets a little bit more complicated when you're dealing with the city of New York as a defendant. So here's an example of construction that was occurring. This is actually a Con Ed vault in Brooklyn. Again, reminding you, things that are really easy for a car to drive over are not going to be the same for a cyclist. So this was about 4-inch variation between the street and the hardware vault. Client's actually right at the intersection. Client's riding at night, around 11 o'clock at night. It's not a well-lit area. He makes a turn onto this street, and there's this vault right there in the roadway. He falls and crashes and hurts himself. I was able, also, I should have talked to this earlier. Google is an incredible resource. Google Earth gives you the ability to travel back in time and get a photograph of it. All right, so whenever that Google Earth car went around and photographed that, you can get a picture of it. So when it comes to street defects, go Google it and take a look. This particular, I didn't take a photograph of it, but in this particular case, when I Google Earth this accident location, and a lot of times I just do it when I'm on the phone with a client. He's like, oh, I got hurt on 3rd and 32nd Street. I just Google it to kind of give myself sometimes, or that's an easy one, but an area in Brooklyn I'm not familiar with, I want to see it as I'm talking to the client. So I Google Earth this location, and there are the Con Ed barricades around this construction site. And at some point, they removed them. I don't know why. Their obligation after removing them was either to come and finish paving the street so that it's flush and level, or put down street plates, but they didn't. So Google Earth gives you the ability to travel back in time and get photographs of this, and I've had that happen to me in more than one case. Also, when you don't know who created a street defect, every marking in New York City streets are color-coded. You all see red paint, yellow paint. They all have different meanings, and some are for electric, and some are for gas, and some are for steam. So if you have an area that's now been cut and repaired, if you could travel back in time and see a marking before it was cut and repaired, you know who was out there working at that site. Also, literally, there's discs placed on construction, like Verizon. When they dig up a street, so that the city of New York knows who was there very quickly, you'll see a little blue or a little yellow disc buried into the street. That's going to tell you who did the dig as well. So this is Kent Street in Brooklyn, and they were doing construction. I think it was for the Brooklyn Park at the time. And these photographs were taken the day after the crash occurred. But my client was traveling on Kent. They had shut down the roadway and were diverting traffic into the bike lane. And as you see in this particular photograph, they have flagmen present to stop cyclists who would be riding in the opposite direction into oncoming traffic. Well, on the day of this crash, according to my client and according to a witness, they didn't have any flagmen present, and they diverted car traffic into the bike lane. He's riding in the opposite direction. As he gets halfway through the bike lane, there are cars parked to his left. There's a curb to his right. He's caught in the bike lane as a Con Ed truck is actually traveling up in the direction at him. He tries to get out of the way and crashes. But I'm showing this to you as an example of when they close a New York City street, these are the things that need to be done. You need to have flagmen present. You need to have cones, you need to have signs, you need to have everything to make it aware to a cyclist that there's going to be ongoing construction ahead. And these are the things we're looking for. Anybody have any questions? I'm moving quick. Yep.
When you talk about these demarcations, temporary demarcations, moving the bike lane.
Right.
And that one instance you said there was a barricade and he hit the barricade.
Yes.
So where's the level of care for the bike rider? He or she's now in the construction zone.
Right.
The demarcation is no longer flat on the ground. There's something raised up. Where's that person's duty to slow down and take some care while traveling through that?
I'm going to argue that I'm not going to tell you there's always an issue of there's always going to be an issue of comparative negligence in every case, right? So New York City or New York State is a comparative negligence state. So every jury is allowed to consider. So the question is, what's the duty or obligation of a cyclist when they're confronted with a dangerous situation? Is that fair?
Well, no, I mean, if a car's going through a construction zone, you slow down because you're in a construction zone. Does the bike have to slow down?
Right, right.
And now the demarcation is different. It's no longer a flat surface. You have something raised.
Okay.
Maybe it's a little of both. There's, your duty as an obligation as a person on the road to keep traffic laws slow down.
Right.
First, and then second, things have changed. It's no longer flat on the ground. You have a raised demarcation.
Right, so you're right, and then so what's the obligation? And again, going back to the issue for the cyclist is, was there anything to alert that cyclist that there was construction ahead, right? So was there a big sign there that said construction ahead? Yes. Well, what'd you do when you saw that big sign there, construction ahead? I slowed down, I didn't slow down. Those are all issues for a jury to determine whether or not the cyclist caused and contributed to the happening of the crash. And you're absolutely right about that. Look, just because there's a defect in a road doesn't eliminate your ability to look for it, right? We all have an obligation to look where we're going, to see what's there to be seen. Just like the contractor who creates a defect that we're not expecting has the obligation to make it aware and apparent to us as well. And then when you're confronted with that circumstance, did you act reasonably under that circumstance? So using this example, if there was a flagman there and my client chose to ignore the flagman, he doesn't have a case, right? But when there's a flagman present, if there's not a flagman present, he doesn't know. If there were cones there and no flagman, right? Well, cones should wake him up to say, hey, buddy, something's going on up here ahead. Slow down, So it's a really good question. And those are always issues that you're dealing with on any case. You had a question, sir?
So I just meant in that dooring instant, because you have the laws on that. of the person is parked legally, not like.
Right.
Taxi in the lane.
Yep.
And it gets a premium.
Yep.
Would that come into play? It's not an absolute.
It's not, and that was that's what I was telling you before. Every single case that I've ever researched on that issue, the appellate division has always said it's an issue of comparative negligence, whether or not the cyclist did anything or caused or contributed to the happening of the crash. And everybody's made the argument that I've made, and I've made that argument in a bunch of lower courts, and the appellate division has agreed with you, what you said, whether or not, and I'll repeat the question, whether or not there's an issue of comparative negligence for a cyclist when he's approaching a vehicle, if he's traveling too quickly, or did he do anything to cause or contribute to the happening of that crash. And the appellate division has agreed with you on 7, 8, 9 cases that I found when everybody's moved for summary judgment on that issue. I got lucky in the lower court, and it's the first time that I'm aware that it's ever been granted, but I had 3 things going for me. Number one, I had the statute. I had photographs that showed the door open. I had photographs that showed him illegally parked in the bike lane, and I had the other benefit of the defendant wasn't able to oppose the motion because they didn't have an affidavit from their client. They never produced their client for a deposition, and they didn't put an affidavit in opposition to the motion for summary judgment. So I had the third thing that might have won it for me. I'm still not 100, but I won, so I'll take it. I'll take the win. Yeah. Any other questions? All right, great. All right, so this is a whole new area of law that's starting to come about, and that's liability of these rideshare companies. A lot of cases that I'm having now involving not just New York City traffic cabs, but are going to involving Uber and Lyft vehicles. And there isn't a lot of case law out there on this issue yet. California seems to be leading on this issue. And the issue of whether or not Uber, as an employer of a driver, is going to be responsible. So in New York State, an employee is vicariously responsible for the acts of its employee. Right? So if you're a construction company or you're a delivery company, FedEx driver has a crash, the driver is responsible for the crash, and FedEx as an employee is responsible for the crash, and the owner of the vehicle is responsible for the crash under 388 of the Vehicle and Traffic Law, under vicarious liability. So what are we doing with Uber? Nobody knows for sure whether or not Uber drivers are employees of Uber. Uber calls them independent contractors. There was a case out in California involving whether or not Uber drivers were considered employees, not for the purposes of an accident, but in that case it was whether or not Uber employees can get benefits as an employer of Uber. And that was the first test case. And Uber had moved for summary judgment as an issue of finding as a matter of law in the federal court, and the federal court said no. They said, for at least as of now, you haven't established as a matter of law they are not employees. There's one other case involving Uber, and again, this is in San Francisco, and a young girl was killed by an Uber driver when she was a pedestrian. And the attorney in California sued the driver, the cab owner, and Uber. And his theory against Uber or Lyft, I think that one was actually Uber, was that the app that the drivers are using as they're driving around distracted the driver as he was looking at the app and caused a crash. So I have one case involving Uber. It actually involves a dooring involving Uber. It's kind of complicated. But the issue is going to be, for me, I'm just starting to do depositions, is whether or not the driver was using that app at the time, and did that app distract him. But presently, there's no case law that I'm aware of other than those 2 California cases. Well, the one California case on the issue of employment, and then the other case is still pending with regard to the distraction issue. Yep.
In Uber cases like that, or TLC cases, how does it go?
Yeah, great question. So the issue is, well, how does no fault play into Uber when you're involved in a situation like this? So the one case that I'm dealing with, I can give you by example, is it's a New York City yellow taxi medallion cab. The bulk of New York City medallion taxi cabs are insured by American Transit Insurance Company. So American Transit Insurance Company, which has $100,000 in liability coverage and $50,000 in no-fault benefits, becomes the primary insurance company for the purposes of the claim. All right. Uber, if you go on their website, you take a look at it, they say, we protect our passengers, we have $1 million in coverage available to you, we have $1 million in underinsured or uninsured motorist protection. So earlier on in the lecture, when I talked about uninsured protection or underinsured protection, Uber will provide that benefit to you, according to their website, if you're involved in a crash. So in my circumstance, liability, the first $100,000 of liability will be primary with American Transit. No fault has been primary with American Transit. And then for liability purposes, the goal is to have Uber being responsible or working as additional coverage or excess coverage with regard to the claim there as well. So, but I don't know how, I really don't know how it's going to play out yet, and it hasn't played out in California. It's real brand new. If I come back next year, maybe I'll have an answer for you, and hopefully it's a good answer. Any other questions on Uber? No, okay. All right, so recent bike law cases. All right. Sounds silly, right? You know, it's something that, again, in New York City, you're not dealing with as often as you are, although this case happened to happen in Central Park. But outside of New York City, you do have people that get chased by dogs on their bikes. And whether or not, they bite their ankle and they fall and crash. It does happen in suburban and in urban areas, and even domestic animals. There's cases involving people being chased by bulls and other things like that in New York State. So I was here last year and I lectured about this case, and this was Dorr versus Goldsmith. And at the time, it was pending going to the Court of Appeals, and they finally reached the Court of Appeals in June. So give you the details of the case. Plaintiff Dorr was riding his or her bike in Central Park, on the loop in Central Park. Defendant Goldsmith was holding his dog on one side of the road when his boyfriend or girlfriend called the dog over to the other side of the road. The dog ran across the path of the loop into the path of the cyclist. Cyclist crashes and gets hurt. Cyclist sues Goldsmith and the other defendant, I forget the name, under the theory of negligently controlling your dog. All right? Now, New York State has a long-standing law of strict liability, if some of you remember from back in your law school days, regarding owning of domestic animals. And the rule has always been in New York State that to hold somebody responsible for negligence in a domestic animal case, you need to prove that the defendant knew or should have known that the dog had vicious propensities. And how do you show vicious propensities? That's either by barking, biting other people, things like that. Well, here the claim was not about vicious propensities. Nobody ever said this dog was vicious. They just said the owners were negligent in handling the dog when it allowed them to run across the roadway. So defendants moved for summary judgment. Lower court denied summary judgment, went to the first department, and they actually reversed, I think I have it backward, reversed and restating the claim. In reviewing the court found the general principles of strict liability for pet owners applied, and it was incumbent upon the plaintiff to prove the case under that theory. So the appellate division said, you got to prove a case under strict liability. I don't care about the negligent handling of the dog. You still have to prove that the dog was vicious. Doesn't make a lot of sense. And there was a very, very strong dissent in that case, so off we go to the Court of Appeals. And we go up to the Court of Appeals, and it was heard in June, and the Court of Appeals said, no, we're going to continue with our standard here in New York State, which requires you to establish any case involving a domestic animal to prove that you knew or had evidence of vicious propensities of that animal. So as it stands now, there's no such thing as a negligent handling claim of a dog in New York State at all. And there used to be leash laws in New York State where everybody would use that as an argument, saying there's a leash law and you had your dog off the leash and that's why you bit somebody. That's out. We're only dealing now with prior vicious propensity and no other potential claim involving domestic animals. And this is one other. Anybody have any questions about Dorr? Because it's a little confusing. Okay. And again, this is reiterating what the Court of Appeals said. The strict liability stands in Dorr, and the dog gets to stay in the park in this one. All right. This is a relatively, I was trying to pull a couple of recent cases. There's some really good new case law about comparative negligence for cyclists. And the issue always is whether or not, in comparative negligence, whether or not somebody could avoid or take steps to avoid a crash. And there's some good Second Department and First Department cases that came down recently that said a cyclist that's given 1 or 2 seconds to react to a dangerous situation can't be held comparatively negligent. So this case, this was the appellate division, affirmed a lower court's finding that a motorist that struck a bicyclist was negligent in failing to see the cyclist as a matter of law. So going back to the pattern jury instruction, and it's a well-settled law in New York State that everybody operating a motor vehicle has a duty to see what's there to be seen. So does, going back to your question, so does a plaintiff has an obligation to see what's there to be seen, whether or not it's a car or a road defect. But when a defendant testifies, which a lot of times they do, I never saw the cyclist before the crash occurred. What was the first thing that made you aware a crash had occurred? It was when I heard the thump, when I heard the bang. So this case, his first department said, as a matter of law, the failure to see the cyclist was negligent as a matter of law, and there's nothing that the plaintiff could have done to avoid the crash, finding summary judgment as a matter of law. And I think we are done there. Anybody have any other questions about what we talked about? Let's say I pulled one more case. Let me go back to some stuff real quick.
I have a question.
Yeah, please.
So whenever you're going back to the evidence where you're using the GoPros and such,
Yep.
you're saying that it's usually the smoking gun in any case. But what if the GoPro camera doesn't have evidence of like the license plate or anything like that? Like how do you actually find, like if it's a hit and run,
Right.
how do you find or determine which, who owned the car, or if that is in fact the car that was there on the day of the accident?
Excellent. It's a great question. So the question is whether or not when somebody uses a GoPro or they're using GoPro as evidence, and there's no picture of the car, there's no other identifying information in the GoPro itself, how can you use that to prove a case for that particular issue? And you can't, unfortunately. It's going to be, part of this is going to be reliant upon your client to identify the car, or hopefully the driver stays at the scene, and the police identify the driver as well. The GoPro, my case, I wish I could play the video for you. I was telling you earlier, I had so much fun. I had the guy identify his license plate. I had him identify the front of his car. I did everything to have him acknowledge that that is his car that was making that turn. So that particular circumstance, I had great shots of his license plate. And then he was able to identify it. We were able to use it just for that individual purpose. But going back to some other issues, a lot of times you do have these hit and runs. The GoPro might not pick it up, but go back and take a look at a store camera, because there are a lot of cases out there that I'm aware of where the camera has picked up people being struck by a car and fleeing the scene. I don't get it. I don't get how somebody hits somebody and leaves the scene of a crash. To me, I can't imagine, but it happens all too often. We don't know if they're drunk. We don't know if they are just panicked and left the scene of the crash. I have a case involving a pedestrian on the intersection of 72nd and York, right in front of Sotheby's. You want good camera equipment? You go to Sotheby's. I have almost 150 feet away. I have a clear shot of the crash occurring. It's a really great tool. Yes.
I'm arguing this issue in front of the second department right now for hit and run, where we have a photograph of the license plate, and the lower court denied the defendant's motion for summary judgment and saying that it should have been admissible because the plaintiff could not authenticate the picture of the license plate that was given to the police officer at the scene of the accident. Judge Shack and the Kings denied their motion.
Okay.
It's on for trial December 1st, and the appeals in the second department as well.
It's going to trial.
I could have issues getting the picture.
Where'd the picture come from?
Picture came from an independent witness who did not appear twice for subpoena to authenticate the picture. So I got a big problem.
You got some big problems. He did you a favor for the moment to keep it alive, but it's definitely going to be an issue. Anything else? I'm trying to, because this guy's saying I was not there. That's what
The guy was not there, and it's Frank Scale from Ficiano. Trying the case. So.
State Farm?
Yeah.
Yeah, they're not laying down on this.
Huh?
Yeah, it's definitely going to be an issue.
A million plus excess of 10.
Bad injury.
Yeah.
Yeah, it's a shame. You can't find the guy who took the photo?
I can find the guy.
He just won't come.
Will not come. He's
You've-
concluded at this point. He showed up twice.
Yeah. So folks, you're seeing the reality of trying cases in New York State. You could have the most perfect case in the world, and it might not be going anywhere because of issues that nothing you did, nothing your client did. It's just the circumstances of the case. Yeah. But, that appeal won't be heard until,
Their stay was just denied.
yeah. Second, when did you perfect?
Well, they perfected.
Okay, they perfected.
They perfected. They already filed the appeal, and they filed an order to show cause and also filed a motion in the appellate division to stay the trial. Stands and goals December 6th. I mean, it's going either way.
Yeah.
I'm just unsure, actually, as long as I have.
Yeah.
So I tried the case. They take a verdict.
Yep.
That appeal still gets heard 6 months down the road.
Yep. Sucks.
Yeah.
But that's, look, Dorr is a perfect example. Dorr, they won that, actually that was motion, never got to trial. But there's a lot of circumstances where you could try a case, get a 7-figure verdict, spend $25,000 on the case, and unfortunately the appellate division later after your verdict tosses it out, and it sucks. All right, I'm out of time. Thanks for your questions.